now has accessed the High Court's order on Gyan Vapi case, which cites reasons for backing Hindu sites. Now it says that key 1991 law is not a hurdle and plea for right to pray, not possession. So mosque side is now going to prepare to appeal order, and devotees have been asked why deny even darshan. So these are the latest developments coming in. Remember, Allahabad High Court yesterday judged Muslim sides pleas against right to worship by Hindu women. Let me go across to my colleague Harish for more on this. Harish, first of all, take us through all the exclusive details as far as the document is concerned.
Yes, in fact, the Allahabad High Court explains why the plea for worshipping filed by the Hindu women petitioners is not barred by the Places of Worship Act. And these remarks, remember, is a big boost to the Hindu sides petition pending in Varanasi court, where they have sought daily worshipping rights at western wall of Gyan Vapi mosque, which has idols, murals of Mahasringar Gauri, Ganesh, Hanuman, Nandi, etc. High Court says very significantly that prayer in this particular proceedings is not for ownership of the disputed property or to change its character, but limited, very limited to daily darshan of idols and murals on western walls like that of other various Hindu gods. This had been going on for past 2 centuries. This is very important and was stopped only between 1990 and 1993, just before and after demolition of Babri Masjid, and even after that it was being allowed once a year on 4th day of Navaratri. This temporal restriction came in as a matter of administrative exigency, then emergent for the government and district administration. The right was not restricted to a single day upon objection or resistance by the revisionists. So Hindus were praying at the Gyan Vapi even on August 15, 1947, the cutoff date, before it and also after it. So the prayer is not barred under the Places of Worship Act. This is a very, very important portion, remember, because the Place of Worship Act says that there should be a status quo maintained on religious structures as on 15th August 1947, but High Court has upheld the argument of the Hindu sides that the Hindu sides have been praying there even before 15th August 1947, before that, on that date, and also later. So this particular petition is not barred. This particular plea by Hindu side is not barred by the Place of Worship Act, which provides for a status quo on religious structures. And let me read out a very important portion of this judgment. Para 100 goes on to say, it has to be clearly borne in mind that the right to worship the deities that the plaintiff seeks to enforce upon the allegation in the plaint and the material placed before the court by parties, short of evidence or defense, is neither a new right that the plaintiff seeks to establish, nor is it a right that was never exercised after or before 15th August 1947. So the right continued to be exercised by the devotees as claimed all through the year up to the year 1990 without hitch. It is this right that the plaintiff seeks to enforce. So these are some of the very important salient features of the judgment, and the Supreme Court very clearly says, therefore it's a matter between Hindus and the administration only. Hindus are only trying to restore daily worshipping rights. Place of Worship Act also not attracted as Hindus not seeking ownership rights on mosque or change its character. For the time being, they are only seeking worshipping rights. Back to you.
All right, so that is what the observation was from the court side. Harish, stay with us. Let me also go across to my colleague Swati, who is going to take us through all those inside details of what exactly the court said while defending the Hindu side. Over to you,
absolutely, Shiva. In fact, Harish just pointed out that the Hindu side's plea is that they are looking for right to pray and not ownership rights. He read out para number 100. Let me take you through para 101. And this is what it says. As earlier remarked, the exercise of that right appears to have run a troubled course between the years 1990 and 1993 till it was restricted to a single day, that is to say 4th day of the Vasantik Navratra in Chaitra. Further, as already said, this temporal restriction came in as a matter of administrative exigency, then emergent for the government and the district administration. The right was not restricted to a single day upon an objection or resistance by the revisionist. The right of the devotees of Mahasringar Gauri, Lord Ganesha, Lord Hanuman and the other deities in the suit properly according to the pleadings in the plaint is an existing right which the plaintiffs as such devotees seek to enforce throughout the year for themselves. It is quite another matter whether the plaintiffs establish this right at the trial or fail, which is beyond the scope of the present proceedings. Hence, like Harish pointed out, the court believes that this is a matter between the administration and the Hindu side. Shivya.
All right, so those are the details as far as the document is concerned. Let me also go across to petitioner Vishnu Shankar Jain, who is joining us with the phone. And Mr. Jain, that was of course a crucial observation that was being made by Allahabad High Court, saying that how would Hindus worshipping daily change the character of the Gyan Vapi mosque? As of course this observation coming in your favor.
Exactly. See, the point in our case is very clear, and we have set out a case that inside the premises in question, we were worshipping till November 1993, until the time when barricading was made there and our rights were restricted. So we are trying to restore the rights which was existing till November 1993. And the fact of the matter is that till November 1993, we were worshipping in the premises in question of various deities. Mahasringar Gauri, Lord Ganesh, Lord Hanuman, and other visible and invisible deities were present inside the premises in question. And that religious character of the property has been changed in violation of the Places of Worship Act. Therefore, we are seeking to enforce our constitutional and civil rights through medium of this present civil suit.
Right. And also, what can we expect next in the case? I mean, the move from the Hindu side.
See, I think this is a matter of trial. And we want in this case that the trial should happen. We should be allowed to lead evidences. We should allow to lead Archaeological Survey of India evidence. Apart from that, commission report is already a part of the record. So we will definitely look forward to the hearing which is pending before the Supreme Court on 6th of July. And after the hearing before the Supreme Court, we will proceed further with the trial.
All right. Thank you, Mr. Jain, for joining in and sharing all those details. So this is what the Hindu side has to say. Of course, as far as the observation from the court side is concerned, it went on to say that if Hindu devotees offering prayers at the Gyan Vapi mosque once a year did not change the character of the place, how will doing it daily or weekly lead to that? So that was a crucial observation that was being made during the hearing of the plea, which was filed by the Muslim side in the Gyan Vapi case. And also, Mr. Jain, now, as far as the Muslim side is concerned, they have also been asked for their next move, wherein they are expected to prepare to appeal order. So in that case, what can we expect in the case? Right. Seems like we lost a connection with Mr. Jain there, but going across to my colleague Swati, who continues to be with us. Swati, now the Muslim side have been asked to prepare to appeal order, and this is also coming in a time when the court just 2 days back gave its order, and the observation came in the favor of the Hindu side.
Right, absolutely, Shivya. In fact, let me take you through another operative paragraph which addresses the concern of the character of the mosque and the sections 3 and 4 of the Act of 1991. It says the other facet of the matter, of course, is, and one already noticed, that the right being exercised all through the year beyond 15th August 1947 and as late as in the year 1993, the enforcement of the right that the plaintiffs seek throughout the year does not attract the mischief of sections 3 and 4 of the Act of 1991. Likewise, the mayor asking to enforce the right to worship Mahasringar Gauri, Lord Ganesha, Lord Hanuman and the other deities located in the suit property at their specified place is not an act that changes the character of the Gyan Vapi mosque into a temple. This is very important, this portion. The court believes that it does not change the character of the Gyan Vapi mosque into a temple. It is no more than the seeking of a full enforcement of a subsisting right that inheres in the plaintiffs and since long exercised by the other devotees like them until a time much later after 15th August 1947. And this at least is the plain
So clearly, the Allahabad High Court defended the Hindu side, saying that they are not asking for right to worship as a community but as individuals. Well, thank you, Swati and Harish, for joining in and sharing all those quick updates. But for the meantime, let's